right, good morning, everyone. Again, this is the public session. We'll do a roll call, please.
Here.
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 Here. Here. Here.
Here.
Here. All right. Let's all rise for the Pledge of Allegiance, and Commissioner Waldman, lead us off.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Have some housekeeping announcements. The First District Court of Appeals graciously let us use their facility, so please respect their rules and have absolutely no food or beverage other than water in this room. Please silence your cell phones. Anyone addressing the commission, please speak up so our recording equipment can pick you up properly. And my fellow commission members, please speak up into the microphone so you can be heard. Members, I ask that you be as brief and concise. That goes to Mr. Jim Wallman over there.
I appreciate that, Mr. Chair.
Hey, it's the first day. I get to do some cool stuff like that. With your questions and comments, we have other number of items to consideration today. Pursuant to Section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determination in financial disclosure cases. If you desire to be heard on matters, please fill out a speaker card and give it to Ms. Fulford, who has her hand up. Awesome. All right, now the approval of the minutes.
Move the approval.
All in favor say aye. Aye. Any opposed? So moved. All right, so now we're on item 4. We have before us a proposed settlement in case, complaint number 17-065 and Keith Doherty. With all the parties and for their counsel, please identify themselves for the record.
Elizabeth Miller, advocate for the commission.
Okay. With probable cause we previously found in this complaint, and now we have before us is the proposed joint stipulation between the commission advocate and the respondent. After considering all materials and presentation of the parties, the commission may vote to approve or reject the stipulation. If you reject the stipulation today, the complaint will go to the Division on Administrative Hearings for evidentiary hearing, or parties could negotiate a new settlement for consideration at another commission meeting. The parties cannot renegotiate and present a new stipulation at this meeting. Complainants have the right to respond in writing to proposed stipulations. We have not received any comment from the complaint in this case. Ms. Miller, you are now recognized to present the stipulation.
Thank you. Good morning, Commissioners. Elizabeth Miller, advocate for the commission. This case involves the respondent's financial disclosure forms for 2014, 2015, and 2016. On CE Form 1, Part F, a filer is required to disclose interests in specified businesses if he is an officer in or owner of such a business. Respondent was an officer in a nonprofit business that put on events such as festivals and concerts. Business interests that are listed on the form on the instructions are banks, insurance companies, credit unions, pari-mutuel wagering, utilities, so on and so forth. Here the respondent, as I stated, he puts on carnivals or festivals and concerts. During the 2014 year, it is alleged that he got a 3-day permit on behalf of his nonprofit business. The Department of Business and Professional Regulations has no record that he obtained a permit or even filled out an application in 2014. Therefore, I'm asking that that allegation be dismissed. In 2015, respondent's business was issued a one 3-day permit to sell wine and beer. In 2016, it was the same, one 3-day permit to sell wine and beer. The nonprofit should have been disclosed on his 2015 and 2016 forms under Part F. I ask that you adopt the stipulation. It's for $250 per allegation for a total of $500. Thank you.
Thank you. Members, or questions from members?
I don't have a question, and I'm going to support the stipulation, but I'm concerned at the amount of fines that we are charging. If something is worth all of the time to bring it to this level, if in fact it is an ethical violation, it seems to me that it ought to be worth $250. Just, you know, I think that if we have a reputation that, okay, if you get your hand slapped by the Ethics Commission, it really doesn't cost very much. I know several other commissioners have raised that same question and concern. I just think it is kind of ridiculous to have all of this, all the time tied up, all the investigation, show probable cause, and end up charging $250. You know, you can take 2 out to dinner at a nice restaurant for that. I just think it's far too small of an amount. That isn't going to affect my vote, it's just a comment for the benefit of the commission.
Thank you, Commissioner.
May I
Anyone else?
respond?
Yes. Did you want to respond?
Yes, thank you. The reason that I agreed to $250 for two reasons. This is a gray area, in my opinion, because his business is not for the purpose of selling alcoholic beverages. His business is for another purpose, and a 3-day permit is sort of a convenience for his customers. And he only received one for 3 out of 365 days per year. He's not selling alcohol yearly, and he doesn't have a license, he's got a permit. This situation, in my opinion, may not be in the spirit of the law or what the legislature intended due to the type of businesses that are specified that must be disclosed. Additionally, if you break down the $10,000 civil penalty on a per diem basis, 3 days is actually less than 1% of a year. It's 82% of $10,000 makes a fine $82 for the 3 days, but he agreed to $250. So that's my rationale.
I saw Commissioner Meg's hand up.
I'm kind of with Commissioner Grant on this particular one. I went through the report of investigation, and I see on the report, doesn't sound like this particular commissioner takes his job all that serious. I see it on page, I think it's number 18, where he hung up on the city manager when he was trying to talk to him. He has several financial disclosure problems. I see where he refused to cooperate with the investigator, and he apparently intimidated the Parks and Recreation Director. So I think you ought to be fined more. I will probably vote for this stipulation, but I don't think this particular commissioner has learned and will learn anything from the actions that we take here. So that's my beef, but I'm okay.
All right, anyone else? Commissioner Newman?
I share the same concern. I thought the whole thing about making elected officials, be forthright and be good stewards of the public resources and the people they represent was a deterrent. And $250, like my colleague said, it's not going to deter anybody from doing anything. I don't understand why, and also you have to look at, I think we were here last morning, and I think you stood right at the podium and you suggested that we take a stipulation because of what could happen if we go, if they took it to the trial or went to a judge, and the cost that was involved, similar to what Commissioner Grant's talking about, all the costs that went into giving somebody a slap on the wrist and get sued somewhere. So my concern is the same. I mean, when you hash these deals out, the rationale to me don't seem well, because the individual that created this whole situation, and that's the reason why we're here, is pretty much getting away with what he done. I mean, we had one, okay, not to go back, but they'll cop for one thing, but not the other, and then we supposed to accept an agreement which arises to being a slap on the wrist. So, I don't know, why you have $10,000 fine and you don't impose them. That's my concern. I mean, if they want to, if they're guilty and they make the proper cause into the whole investigation, they should pay the full fee. That's just my opinion. And I don't know why we have those. If we're going to let them, if we're going to do some divisions and figure out 365 days a year, you know, and then charge them the minimum that we can possibly charge them. And one more comment I want to make: just selling one day of alcohol. Events don't prosper without alcohol. They make a ton of money out of alcohol. That's what all the profit is. And goes to anything, for the record.
Okay. All right, anyone else? Seeing none, okay. The respondent, you may wish to comment on the stipulation. Is respondent here? Nope, okay. All right, moving on to the next one. Do we have a motion to either adopt or reject the stipulation?
I move adoption of the joint stipulation.
Is there a second?
Second.
All right, second there. All in is there any additional discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion is moved. Thank you. All right. Okay, so I think this is where the attorneys might not be here. Are they here? He's not here. So we'll move, we'll move to opinions and then come back to agenda item number 4. So, let me jump ahead here. This one? All right, cool. All right, so the next agenda item is the consideration of advisory opinion. There are 2 advisory opinions on today's agenda. Any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of the disclosure laws or standards of conduct to him or herself, or anyone who has the power to hire or terminate another public employee may seek an advisory opinion from the commission about himself, herself, or that employee. The advisory opinions are based solely on facts provided by the requester and are legally binding on the conduct of the issue. File 2793 was considered at our January meeting, and at that time, we asked staff to make some changes to the draft and bring it back before us. Is the requester for file 2793 here? Nope. All right. Mr. Gray, you are recognized to present the draft opinion of 2793.
Thank you, Chair. As the Chair just said, this is a redraft of an opinion that I presented to you all during the January meeting. Very briefly, it concerns a city commissioner for the city of Margate who'd like to receive a property improvement grant being issued through a city program. Through this specific program, it seems that if her grant application is approved, she'll be entering into a recognizable contractual relationship with the city manager's office, and that's a city agency that reviews these grant applications and disperses the funds. As I presented to you in January, I think that technically meets the elements of the first part of Section 112.313 subsection 7A, because she'll have a contractual relationship through this grant arrangement with an agency, the city manager's office, that's being regulated by her agency, the city commission. And that does meet the elements of the first part of Section 112.313 subsection 7A. Now, during the last meeting, you emphasized several considerations as to why this conflict under this particular program can't be negated, such as the fact that she was involved in setting up the program and now will be receiving funds through it. The fact that the funding for the program appears to be finite, and that means that if she receives funds through the program, others might not be able to. So I've tried to bring those out in this redraft. The opinion is a few pages shorter. It concludes by saying that under the unique circumstances presented here, as she receives funds through the program, she'll have a conflict of interest under the first part of Section 112.313 subsection 7A. I present this redraft now for your approval, and I'm happy to answer your questions.
Thank you, sir. Questions from members?
I move approval as presented.
Well, I did see that Commissioner Newton had his hand up. Did you have a question?
Yes, well, I'll just comment. I received the email pertaining to this particular, report about this individual, and a little bit of background information. I did receive that over to, I don't know what happened with it, but it was pertaining to this case.
So I would recognize our Executive Director.
Yes, members, we did receive some feedback by email from a member of the public. Because you are sitting in a quasi-judicial capacity, that information could not be shared with all of you or taken under consideration with this opinion. We have to operate within the information that was brought to us by the requester.
Okay.
And I did reply to the member of the public and let them know that.
Okay. Is there anyone else on this side wanted to say, or go ahead?
I just want to compliment you on how you drafted this and changed the opinion from last meeting. I think you did a great job. I don't know that I really agree with everything. I think we might be opening the Pandora's box with some of this stuff and maybe being a little bit limiting too much, but I think you did a great job drafting this.
Okay. So, yeah, absolutely.
That's what I wanted to say, the first part. I don't know whether we'll make it more confusing or worse, but I think it was a tall order, a very challenging, confusing set of directions. And so mostly, I know it's your job, but thank you.
All right, so Commissioner Grant moved the opinion.
Second.
Commissioner Moore seconds. All in favor? Aye. Any opposed? All right, so it moves, so adopted. Thank you, sir.
Thank you.
All right, moving on to the next opinion. All right. Next opinion under consideration is File 2794. File 2794 was originally scheduled for our January meeting, but the chair granted a postponement request. Are the requesters for File 2794 here?
They are.
They are, okay. Can you please state your name for the record?
Both of you, if both of you would just like that, if I may, here, for the John Meisel.
Johnny Mosul.
My name is Lindsay Whalen from the law firm of Houston Rock here in Tallahassee. We serve as district counsel for the West Villages Improvement District.
Okay, thank you. Steve, you are recognized.
Thank you, Mr. Chair. Commissioners, John Meisel is a member of the West Villages Improvement District Board of Supervisors. He was elected to the district board in November of 2022, and at his first board meeting, during a discussion about his potential conflicts of interest, he requested that Lindsay Whalen, who is counsel to the district board, request this opinion. They are both here today and available to make a brief presentation, perhaps if they wish, and answer any questions that you may have. The district spans about 12,000 acres. Within the district lies the Grand Paradiso community, which is operated by a homeowners association. All homeowners of the Grand Paradiso community, included Mr. Meisel, are required to be members of the HOA. It's important to note that the HOA is organized as a nonprofit corporation. In addition to being a member of the HOA, Mr. Meisel is also a member of the board of directors of that HOA. My understanding is that he joined the board of the HOA well before his election to the District Board of Supervisors. According to the opinion request, the HOA has one business entanglement with the district. The HOA has one business entanglement with the district. The HOA buys its irrigation water from the district. This arrangement is the source of a lot of consternation for the residents of the HOA, and they have filed a lawsuit against several parties, including the district, to dispute the fees and services related to the provision of irrigation water. In that lawsuit, Mr. Meisel serves as the HOA's corporate representative, meaning that he acts as the HOA's principal witness and its liaison to its counsel. With that background, Mr. Meisel, through the requester, asks whether he has a conflict of interest. As you know, Section 112.313, subsection 7A has two prohibitions in it. The first part of Section 112.313, subsection 7A, prohibits a public officer, like Mr. Mizell, from having employment or a contractual relationship with a business entity that does business with his agency. The second part of the statute prohibits a public officer from having employment or a contractual relationship that creates a continuing or frequently recurring conflict between his private interests and the performance of his public duties, or that would impede the full and faithful discharge of his public duties. In many other opinions, you have described this second prohibition as entirely preventative. It's preventative because it does not require the public officer to take any affirmative action to create the conflict of interest. As the case law suggests, the conflict exists if the public officer has an employment or a contractual relationship that tempts him to dishonor his public responsibilities. When we look at Mr. Mizell's situation, we see that he does have a contractual relationship with the HOA. In a number of opinions, and they're cited throughout the draft, the Commission has found that a membership in a nonprofit corporation creates a contractual relationship between the public officer and that nonprofit. It's plain to see that Mr. Mizell has a contractual relationship with the nonprofit, which is doing business with his agency through the sale of irrigation water. In the absence of an exemption, that would create a conflict of interest under the first part of Section 112.313, subsection 7A. There is, however, an exemption available to negate that particular conflict. As we point out at the bottom of page 5 of the draft opinion, the purchase or sale of utilities services is exempted from the application of Section 112.313, subsection 7A. Because the provision of irrigation water is a utility service, the conflict arising from its sale is negated. The draft also explains in footnote 6 that there is a second exemption available to Mr. Mizell regarding that conflict, but in the interest of time, I won't get into that right now. Our analysis of the situation, however, does not stop there, because there is another scenario that requires review, and that is the HOA's lawsuit against the district. In the draft opinion, staff cites 3 ethics opinions that stand for the proposition that a contractual relationship with a business entity, without facts and circumstances indicating that the public officer would be tempted to dishonor his public responsibilities, does not create a conflict of interest under the second part of 7A. However, when that contractual relationship coincides with the public officer being seated on the board of directors of that business entity, while that business entity is suing the public officer's agency, a continuing and frequently recurring conflict is created. In that scenario, where the public officer is a representative of a business entity in a lawsuit against his own agency, he owes obligations to both sides of the lawsuit, and he could be tempted to dishonor his public responsibilities in favor of his private responsibilities. As a member of the board of directors of the HOA, Mr. Mizell owes responsibilities to the HOA and its more than 1,800 members. As a public officer on the board of supervisors of the improvement district, he owes responsibilities to his agency. The draft opinion stands for the proposition that he cannot possibly maintain the public trust in the context of this lawsuit because the responsibilities he owes to each side almost certainly and likely frequently will conflict. As I said earlier, the statute is entirely preventative. Mr. Mizell does not have to take any affirmative action to create the conflict. The conflict arises from the coexistence of competing interests, not from his succumbing to the temptation to dishonor one interest in favor of the other. Mr. Mizell might very well have the strength of character to resist giving way to the temptation to dishonor his public responsibilities, but that is not the relevant concern here. The statute essentially makes a policy choice that public officers should be free from conflicts, even if they could resist them. Page 8 of the draft opinion concludes question 1 by suggesting 3 solutions to Mr. Mizell's conflict of interest. He can end his membership with the HOA, but that's not really feasible given that his membership is mandatory. He can resign as an officer of the HOA and remove himself as a representative from all representative capacities in the lawsuit. This would essentially eliminate the circumstances that create his obligations to the HOA and its members. By merely being a member of the HOA and not an officer and a corporate representative of the HOA, he would no longer have any particular responsibility to the HOA or its members. Lastly, he can resign his public position, which would eliminate any legal requirement to remain in compliance with the Code of Ethics. Moving on to the other questions in the draft, questions 2 and question 3 are by comparison much simpler to explain, and if you'll allow me a very brief indulgence, I'll briefly cover them. Question 2 asks whether Mr. Mizell has a voting conflict if he votes on any matter pertaining to the lawsuit. The draft suggests he does not have a voting conflict due to the large number of members in the district who would be affected in a manner equal to Mr. Mizell by any vote he might take pertaining to that lawsuit. The draft also includes cautionary language suggesting that he might want to abstain anyway under Section 286.012 because of the appearance of a conflict and his heavy involvement in the lawsuit. Question 3 asks whether Mr. Mizell's involvement in a completely different lawsuit creates a conflict of interest for him. The short explanation here is that the lawsuit was filed by a political committee of which Mr. Mizell is the chairman and a member. The political committee is suing the city of Northport, which is not his agency, to seek the de-annexation of certain areas. His agency, which is the district, is not involved in the lawsuit. Because he doesn't owe responsibilities to both sides of this lawsuit, and there is no official action he could take as a member of the District Board of Supervisors to affect the lawsuit, the draft finds that he does not have a conflict of interest arising from this lawsuit against the city. I offer this draft for your consideration, and I am available to answer any questions you may have. Additionally, I want to remind you that Ms. Whalen and Mr. Mizell are here, perhaps to make a brief presentation if they wish, and to answer your questions as well.
Okay. Thank you, Steve. Any questions from members? All right, Commissioner Newton.
Steve, this is one question, and you touched on it already. You said that being, you live there, being a member is mandatory. Is being a member of the board mandatory?
Being a member of the board is not mandatory.
Commissioner Wallman?
Thank you, Mr. Chair. Why couldn't one other alternative be that he just abstains on his board from any participation in this?
It's a great question, and I do cover it in the draft, and I'm looking for that right now. It's at the it's footnote 10 of the draft, which is at the bottom of page 8. We have said in several opinions, many opinions, in fact, I cite one of them here, the one that covers it the best. It's CEO 94-5. Abstaining from any votes relating to this matter will not cure his standing conflict of interest under 112.313 subsection 7A, because abstaining is not a cure under that statute. Abstaining is only a cure under the voting conflicts law. There are many things he could do as a member of the board that outside of voting to affect this thing, which is why the statute does not allow abstaining to be a cure. For example, he could attend shade meetings about this vote, about the litigation. He could be tempted to divulge shade information to the other side, which would be a violation of the Code of Ethics, but he may be tempted to do it nonetheless. He could be tempted to put things on the agenda relating to this. He could participate in discussions, and you wouldn't know necessarily whether or not it's him speaking on the matter or his HOA. There are lots of things that he could do outside of voting that would affect this, that would be conflicting for him. It's not that, and again, this statute is entirely preventative in nature. It prevents him from having these conflicts in the first place. Even if he could take a step to avoid such a conflict, like abstaining, for example, the statute says he shouldn't get to that point because he has this conflict.
I'm talking about abstaining from the board, on his board, not the board that he's on, not the public board. I'm talking about the private that he's with. Mm-hmm. Why can't he just not be involved in any of that from that side?
Well, again,
because and I say that because if I understood what you said,
yeah.
If he's not on the board, he can still do the same thing. He can divulge things to the other side that happened in a shade meeting. He can do all of that even if he's not on the board. So I'm saying, why can't he just be not involved at all in the lawsuit from the,
As a member of that board, he owes them responsibilities. He has responsibilities that a regular member of the HOA does not have. He's in he's in a representative capacity representing the interests of over 1,800 members and residents of the HOA. To sit there on the board and do nothing, I mean,
it would be no different than when one of us up here abstains from a certain matter if it comes up because we would have a conflict here. Yes, our responsibility is to vote or discuss or do whatever, but we can't when there's a conflict. So I'm saying, why can't he, with the HOA, just abstain from any participation in that?
well, he would still have all these public responsibilities that he still might be tempted to dishonor because he owes obligations to the other side, even if he opts not to partake in those responsibilities.
Hear your question. Commissioner Ankers has a question.
I withdrew it, but the chair asked me to say it anyway. I was actually just trying to perhaps help respond to Commissioner Waldman's question, but I thought better of it. Now I've been called out, so I have to try, which is, if he is just, I thought you were saying if he was just a member of the HOA, he wouldn't be privy to the information shared in an executive session of the HOA board in which the litigation is discussed, so he wouldn't have the opportunity to share. So I thought you were originally asking, what's the difference between him being a member of the HOA and sharing all of that versus being on the board?
What I was saying is, if he's, even though he's on the board, if he abstains from any involvement in that matter, why wouldn't that be a cure, much the same as you've suggested that, of course, he could, he and likely should abstain as a public official. He should abstain from involvement in this because of the appearance that might be there.
And if I understood counsel's response, I think in practical terms, if we were just working with the private sector or real life, your solution would probably work. It's just that the way that the statute is set up, the voting conflict versus the other statute that creates just like a per se conflict of interest. Doesn't matter if you could solve it in some practical terms or not. It just is.
That's right. I mean, he because he owes those responsibilities elsewhere, that is the conflict. Regardless of whether or not he chooses to honor those responsibilities on the private side, he's got public responsibilities, and the public does not know, the public knows he's conflicted and does not know if he's holding his end.
Great. And thank you. I'm glad that you did that, and you explained that. So now I'd like to bring up the requester, Ms. Lindsay Wehan, who is recognized to present her draft opinion 2794. For her opportunity to speak. Yep, come on up. Present. That's what it is.
Hello, Commissioners. I already presented myself earlier. I'm counsel to the West Villages Improvement District. I'm really just here to monitor on behalf of the board. I don't plan a presentation, but happy to answer any questions that you may have.
Okay, thank you. All right. Mr. Mizell, you are given an opportunity to speak.
Good morning, Commissioners. Thank you for the opportunity to be here today. I greatly appreciate it. I do have a handout that I'd like to provide to the Commission, if that's appropriate. You're okay with that?
I went right to the phrase that says, with plenty of time on my hands.
Why do you want to be involved in all this?
That's right.
Well,
Because he has plenty of time on his hands. That's what I'm saying.
So that's a very observational comment you made there, Commissioner Ankers. I'm here today because I feel very passionate about what I do in the community. I'm retired. I've worked for IT organizations my entire life, 10 years in the Army, and IBM, HP, Cisco Systems, and multiple roles and capacities till I had the opportunity to retire at 55, and I'm now raising a 6-year-old grandchild from day one. So enjoy life, but I have time on my hands. And so I ended up getting involved in local issues, first of which was mentioned the contraction effort. I'm the chairman of that group, trying to get away from the fiscal irresponsibility of a municipality under Florida Statute 171. I've learned a lot about law, but I'm not an attorney, and I didn't stay at a Holiday Inn Express last night. But having said that, I provided you with a little bit of background and the first page there. But as it relates to the ethics opinion, I want to first thank Mr. Zolkowski for the time that he's afforded me and understanding the challenges associated with this issue that's been raised. And I agree with him almost in entirety, with the exception of one thing. When he was talking about my conflicts, he referenced the exception that he applied to subsection 7A, the first part. However, when you read the exceptions for subsection 3 and subsection 7, it doesn't specify the first part. It says subsection 7 in its entirety, for the sale and use of utilities. And there's no dispute, this is a utility. So the ability to say the first part there's a conflict is cured by the exception. However, the second part of 7A is not cured by the exception, doesn't fly, based upon the way the statute's written. When you read the statute, under exceptions, section 12, it says, which states, in addition, no person shall be held in violation of subsection 3 or subsection 7. It doesn't say subsection 7A, the first part. It doesn't say subsection 7A, the second part. It says subsection 7 in its entirety. Again, I didn't stay at a Holiday Inn Express last night, but in reading the plain verbiage of the statute, that in itself cures. Commissioner Walden and Commissioner Ankers, I thank you for your questions. I have already recused myself from any and all meetings, shadow sessions that Ms. Wayland can attest to related to the irrigation. I provided more information. While Mr. Zukowski, I'd asked if he could provide a transcript from the recent hearings associated with the irrigation, which we got a temporary restraining order issued by the 12th Circuit Court, which I provided in its entirety, but I've also provided some excerpts and highlighted. But when you look at the misuse of public position in subsection 6 of 112.313, it says, no officer, employer, or agency or local government attorney shall corruptly use or attempt to use his or her official position or any property or resource, certainly water is a resource, which may be with his or her trust or performs his or her official duties to secure a special privilege, benefit, or exemption for himself, herself, or others. And I emphasize benefit or others. More importantly, when you look at what the district is, and this is why I ran for it, and by the way, I was elected with over 72% of the populace vote. My community makes up 2,000 homes. There's over 10,000 homes. There's over, I think now the number's almost up to 12,000 registered voters within the district. So I had a resounding support in my representation for the improvement district. And it's because I've been witnessing for many, many years, well, not many, we'll call it 3 because that's how long I've lived there, significant abuse by the district in their use of not only funds or bond monies that are paid off by the residents, but also the relationship, which I believe is a significant conflict between the district and the developer. The Board of Supervisors for the district is made up of 5 representatives, 5 supervisors, one of whom is elected. That would be myself. The other 4 are appointed by the developer. There's never been a vote on that commission that's been anything less than 4-1. And often and the only time that dissenting vote is given is by the elected individual, my predecessor and myself. The ability to effect change within the district through the voting methodologies, if you will, or just equity is never going to happen so long as those 4 members are employees. And often, and by the way, they do a great job when it relates to issuing bonds and that sort of thing, but there are side arrangements, which dovetails right into this irrigation issue and litigation that's ongoing. When you look at I pulled out some excerpts of pages, and I've highlighted it. So the judge says, and this is directly the oral transcript from Judge Carroll. So we have a rate study that is presented to a Mattamy-controlled controlled governmental unit to approve a fee that directly benefits Mattamy. Go back to subsection 6, where it talks about benefits. To secure a special privilege benefit for others. Now, WVID is certainly protected by their ability of having a conflict of interest per se and subsection 1. However, it also states conduct by such officer or employee that is prohibited by or, with emphasis, otherwise frustrates the intent of this section shall be deemed a conflict of interest. This irrigation is a perfect example of where they're frustrating the intent of this section by signing a 100-year agreement for not the provision, but availability of a well availability fee that would pay the developer $2.88 billion over the course of 100 years. If that's not a conflict and benefit for others, I don't know what is. I know that issue is not before you today, but I'm here today, not because I did anything wrong, but I'm here to serve the community, not only my community, but all residents of West Villages Improvement District, to ensure that there's transparency and accountability, and I will continue to abstain from voting on the Board of Supervisors for the district. Oh, by the way, I've also cured the designated corporate representative title that I've been labeled with. That was adopted at March 1st at our board meeting, where the president is now the designated corporate resident. The reason I got that is I was deposed by opposing counsel from WVID, and when I went to the deposition, the attorney said, "Well, who's going to be the corporate designated representative?" And we're like, "Well, what does that mean?" And they, "Well, who's going to testify the most?" Well, I said, "Well, that would be me." And I ended up giving a deposition for over 6 hours. I testified for over 12 hours on the stand and 2.5 days of hearings, because I know the irrigation issue inside and out. Irrespective if I'm a board member or I'm a supervisor, I know it better than anybody. And that's why I testified on behalf. I'm trying to right a wrong, and if this commission, which I will respect whatever your decision is, but I will continue to abstain and recuse myself from anything having to do with this litigation. But again, you go back to the exemptions. It's not the first part of subsection A. It's not the second part. It's all of A. And this is no doubt a utility. And I will, again, I didn't do anything wrong, but I respect your opinion and trust in you that you'll make the right determination. Last thing I'd like to ask is, after reviewing this, if there's any assistance or direction that you can point me in to make sure that there's transparency and accountability, not only for the other 4 supervisors, but myself, I would appreciate it. Thank you very much. Any questions?
All right, thank you. Commissioner Newton, you're recognized.
Sound like you got a conflict.
I can't tell you how many sleepless nights I've had, Commissioner Newton.
What I want to ask you was, this situation, I know you have to be an RASC, you have to be a mandatory member of the HOA, but it's not mandatory that you be on the board. Prior to you running for, or running and getting on the water district, was this issue, was around?
Yeah, absolutely, you're correct. In fact, it was identified in early, I would say, April, when I joined the board of directors for the community. I was seated on as a director, and although I received the most votes, I did not want to be a president. I did not want to be a vice president. I just wanted to be a participant to help the community. We started communicating with the district, trying to resolve the conflict of the two agreements that are in violation of 720.309, and was met with resistance and basically the attitude of, we're established by the Special Act of 2004, 456 of the state legislature, and we can do what we want, and we're going to give you the Heisman and either pay up or go to court, or we'll terminate your water.
My next question is, when you ran for, when you got on the water district, do they have any legal counsel or representation that advises you guys?
That would be Ms. Whalen, and to correct the record, when Mr. Zukowski said that I'm the one that requested it, it was actually Ms. Whalen that had requested an opinion, and if I had any opposition to that, and I said, no, not at all, I welcomed your opinion.
So you do have legal counsel that,
She's here today, Ms. Whalen.
that advises the district?
Correct, Ms. Whalen, she's here today. She's the one that's submission.
And I'm just asking this because I went through the same thing from a legal association president, and I got on counsel, and I've been in counsel for a
Congratulations, and I apologize.
Yeah, so labor law. But I knew that when I ran for council, I got on council, I had to resign as the president of the association. I couldn't do both because normally the council under the neighborhoods are going to battle with the city, which is the elected officials. So to represent them fairly and remove any
Appearance.
of conflict, I consulted our legal representation and I asked them, could I do both? And he said, you would have to resign. So early on, before there was any problems, I had to remove any appearance of conflict. While I see your opinion and your passion, everything was done knowing that this would create a conflict because you can't serve two masters. Obviously, from your passion, I hear there's a big problem with the water district and the people that sit on that board. And what happens more times than not with HOAs, they'll be on the run to get somewhere to be able to, I guess, carry their plight and fight for them, which is nothing wrong with that. But where lies the problem is they have got to disassociate themselves with any conflict as they get to that plateau or that platform. I'm not saying you're wrong, I'm not saying you're right, I'm just saying that what it has done was create a conflict. That's all.
And thank you for your comments, Commissioner Newton. And I would agree that the appearance of potential conflict absolutely exists. But as you asked and I indicated, I was elected to the Board of Directors first and then subsequently ran. By the way, my predecessor on the Board of Supervisors was also a member of the Board of Directors. So I've been kind of following in his footsteps, and there was never an objection to that. It wasn't until I joined the Board of Supervisors and the district was being held accountable about the irrigation, for which, again, 4 of the 5 supervisors are employees of the master developer. So it's the master developer. So that conflict of interest, albeit it's protected per se under 112.313 subsection 1, but there's also, I'll go back to, you're never going to alleviate all the appearance. I think it's all about character. And I've committed, and I will be held accountable. If I ever cross that line from an accountability perspective, I expect to be held accountable in front of this commission. But I promise you I won't.
Okay. Members, any other questions or comments? Questions?
Thank you, Mr.
You're
Chair.
recognized.
I just wanted to pose to Steve, he made an explanation that sounds credible with what he's saying, and I'd just like to hear a response to that regarding subsection, the 7 and 7A and how that works.
And I think probably what you were also referencing is the exemption, the application of the exemption to both subsections
Correct.
versus one.
Said that better.
Well, I just wanted to make sure that got covered because that matters.
Right. Thank you, and through the chair, thank you, Commissioner, for asking the question. So what Mr. Mizell has proposed is that he believes that the exception that we apply to the first part of 7A for his conflict there, which, again, the conflict that we're identifying that would violate the first part of 7A is that there is an actual doing business relationship between the HOA and the district, right? So because there is the doing business relationship, which involves and is entirely consists of the purchase and sale of irrigation water, which is a utility service. So that conflict is negated by the application of the exception, which reads in whole that there won't be a violation of 7A or 3 if the conflict, if the purchase or sale is for legal advertising in a newspaper, for any utility services, or for the passage on a common carrier. So this revolves around the purchase or sale of utility service. So we negate that conflict. The second conflict that we ended up talking about in this draft is not about the purchase or sale of a utility service. The situation that gives rise to the conflict is that he is involved in a lawsuit where he serves as a representative for both sides of the same lawsuit. The conflict does not arise from the purchase or sale of the utility service. The doing business relationship was the first conflict that we identified. We negate that. The second conflict now is not about a purchase or a sale. It's about this lawsuit where he sits on both sides and, as Commissioner Newton said, serves two masters.
Okay.
But the lawsuit is over utility service.
Yes.
So it's the same thing. I mean, it's all utilities.
You're welcome to conclude that, and it would be easy to write the draft that way. I disagree that there is two separate prohibitions under 112.313 subsection 7A. One is specifically related to the transaction of business, and the other one is separate and apart from that, any other situation or circumstance arising from a contractual relationship or an employment that creates a continuing and frequently recurring conflict. The conflict that we're finding under the second part of 7A does not arise from a business transaction. That's the first part. This arises from a lawsuit that he is involved in where he sits on two sides, advising both and performing duties for both.
But it all arises out of that contractual relationship. That's what the litigation is. I mean, I see it from the standpoint, as a public official, he should abstain, as opposed to having to remove himself. He's not going to be a participant in any shade. If he doesn't participate in shade meetings, it's litigation. He wouldn't have any other knowledge other than what every other citizen would know in that community.
Abstention, according to our previous opinions, and this relates to the conversation that we just had a few moments ago, abstention would certainly firewall him from his voting duties. But there are, as you know, sitting on the governing board for an agency yourself, there are other things that you can do on a governing board or on a board besides voting. There's plenty that happens. Like I said, adding things to an agenda would be one of those things. For example, participating in discussion, rallying votes to one side or the other, framing questions. All those things could be done not in the public interest, but serving a private interest. And those have nothing to do with a vote.
But if he did that, then he'd be violating the sunshine.
No, not necessarily. Well, he could also be tempted to violate the sunshine, perhaps, too. You're right about that.
Well, I'm saying if he has discussion with any commissioner, any other commissioners on his board, then that would be outside of what he's talking about.
No, but he could do it in a public meeting as well.
But if he's abstained, everything.
But if he does it in service of the private interest, that would be the problem. That's exactly the problem that's prohibited.
Okay. Any other members or questions? All right, do we have a motion?
I move the adoption of the advisory opinion, and I'd like to comment after if it's seconded.
Okay. All right, now we're in discussion. Commissioner Ankers?
So thank you both and all three, including Ms. Whalen. think this is the first time that some of my professional interests have converged in one otherwise probably boring opinion, which is that I represent water utilities, and I represent special districts, and I represent HOA boards in my capacity as a lawyer, and now serve on this commission where we blend all of these things together. And one of the constitutional provisions that came to mind as I considered this opinion, although it's not exactly applicable to your situation, I think the rationale behind it is, and that is the Constitution's prohibition on dual office holding. And that applies to two public entities, and I realize you don't serve two public entities, you serve one public and one private. But the rationale of that, in part, is that there is an opportunity for conflicts of interest to arise, and even with those with the strongest of character, which I will assume that you have, although I don't know you, I will also disclose to you that I think all people who run for HOA boards either are saints or they're insane, and I usually reserve judgment.
I'm a little bit of both.
You still have time to prove which side you're on for me. So don't say anything else that puts you in one of those categories. But I think that part of the art of serving, is to be able to represent all of those different interests at different times. But you had mentioned that the law doesn't prevent a conflict of interest, character does. And regardless of what your character is, I think that the law does prevent a conflict of interest. Whether you like it or not, whether it works all the time or not, that is what the law does in this somewhat complicated analysis. And I think that's what Commissioner Waldman's struggling with, is that it's just the law in the way that the statute is written that creates the conflict, even if he has ways of sort of working around it by the way that he behaves or conducts himself. So you asked if we had any suggestions, and although I am privileged not to give legal advice at all or even practical advice, what stands out to me as the way to solve this problem is that part of your service is to go find another good servant who represents the interest of the HOA that doesn't also serve on the board, or vice versa, finding someone who will serve in this capacity on the district board but doesn't serve on the HOA. That's the elegant way of still perpetuating the interest that you are trying to achieve. And the other issues that are problems that many, many boards and many development districts and many developers and many residents have in terms of continuing conflicts and frustrations, those are going to continue to exist. But it is very possible, especially with over 1,000 people in an HOA, that there's one more out there that can bring some time, some talent to this situation and be able to advance the same interests that the HOA has on this board.
I know my wife would appreciate your opinion, as much as I want to serve on both boards. And again, if it's the commission's final opinion today that I resign, as I mentioned, I will effectively resign today from the HOA. As much as I don't want to do that, I want to be able to serve both masters fair and equitably, but I will follow your direction, and my wife would be, and so that's part of the insane part of me coming out, right?
Okay.
No judgment.
Commissioner Meggs, you're recognized.
I appreciate what Commissioner Akers said. Unfortunately, I just got elected president of my homeowners association. and I got elected because nobody else would do it. And I've only been in office now 2 months. I am trying desperately to be impeached. No provision for
Well, I
that.
think you and I should hang out a little bit together, and we'll help you with that. But
So I am very sympathetic to where you are, and I'm very sympathetic to, well, it's kind of pathetic that people will not get involved in doing the right things. In my neighborhood, for example, right now, it extends back 3.5 miles of dirt road. It has turned into a racetrack. So we voted for speed humps. I installed the speed humps. I put signs up. People run over my signs. And so I'm trying to get impeached.
We have a back gate issue just like that, but I can,
And so I do think probably you need to be impeached from your homeowners and then fight the good fight at the other area. So I'm sympathetic to your plight.
as much as we'd like to think there's other people as insane as I to run for the board. We had 4 open seats, and out of 1,935 doors, we only had 5 candidates for 4 seats. So people aren't knocking down the doors to serve the community.
All right. Anyone else on this side before I go over this side? All right, Commissioner Newman, close us out.
Yes, a potential solution, one of my last pieces of legislation with the government side was to go to HOA I was asking the special taxing districts to restructure the board to have different requirements, like they live in the district, they actually live in the actual taxing district, the individuals on that board, also the makeup of elected officials, appointees, and business. Try to write the balance, so that's something probably and it could be probably addressed in a local bill, which means the residents when I was there, the medical representative of our local bill, we always support it because they know what's best, and they're making the rules, try to govern for them on a local bill, because it doesn't affect the states, it doesn't affect that local municipality. That's an option you can have. But I share your pain, because I was doing it. I wanted to, the reason I ran for city council, because we didn't have a park in our neighborhood. I mean, my kids and all the kids were in the street. That's where they played, in the street. And people flew up and down through there. And they told us that they wouldn't put a stop sign in until someone probably got hit, killed, which didn't make no sense to me. So I asked for a park, and they told me all these stories about how these other council people want to park, and they're going to get one first. I said, well, if I got to go to council to park, but when I got on the council, I had to settle myself in the neighborhood. But I still advocated and eventually did get a park by different means, but I was in a position and to do that, and I had a platform to do it on. And every time I would speak, I would talk about how my kids play in the street. Everybody got 3 or 4 parks, and why? Because my kids are playing in the street. We got multiple parks in the neighborhood. We got multiple dog parks. I love dogs too, but I kind of want my kids to be able to play something safe too. And I was able to do that, so I share your pain. But as I said in the beginning, it's just hard to search two masters, and that conflict was because you went up, but you didn't sever, and that came with you.
I'm with you. Did they name the park after you? Did they name the park after you?
One is 1 and 2, but
Okay. That's wonderful.
Our charter requires that you be deceased.
Right.
Not ready to die.
Okay, good for you.
Commissioner Wallman, you're recognized.
Thank you, Mr. Chair. Well, I too happen to be the president of my homeowner association. But it's actually similar to what his issue is, because I actually, the community I live in has only 10 homeowners. And so it's hard, I mean, to get people who want to be involved. And my opinion would be that one of the, and I guess I would disagree with this opinion, is that I do believe as an elected official, he should have the opportunity to abstain from involvement in the litigation. For instance, let's say when I was a city commissioner, I get injured, and I sue the city because the city's negligent. Do I have to then, what do? I would abstain from any involvement in that decision-making that the commission would make. I'm not, or if I look at it the way you're saying now, I'd have to dismiss the lawsuit against the city because I couldn't sue them because it's the same thing. As I view it, I see Steve's got his hand raised, so, and I certainly welcome a response, but I do believe that an elected official should be able to serve on a homeowner association board, should be able to sue the body that they, or the municipality or whatever body it is that they want, and they just have to, responsibility is like we do here all the time, we abstain when, or recuse ourselves when we have a conflict. And I believe that that's what the opinion should state, that he is one of the alternatives, is just to abstain.
Come on now, Steve.
Through the chair.
Yes, sir.
We were worried internally when we were crafting this draft opinion that anybody might confuse what's happening here, where this opinion could be read to discourage somebody from filing a lawsuit of a discriminatory action, a public employee that's been discriminated against. They feel like they can't file a lawsuit against their agency. And that's not what this is. This is, in your personal capacity, you can file lawsuits about yourself to pursue your rights. And this draft opinion will not discourage you from ever doing that, from representing yourself. What it does is it says you will not be able to represent someone else, another business entity, against your own agency. And that's all that this stands for. And this draft will never be read to prevent somebody from pursuing their own personal rights, either civil rights or other rights, against the agency if they've been wronged by their agency, if they have a claim personally against their agency.
Awesome. So we have a motion to approve and second. All in favor?
Aye.
Aye. All opposed?
No?
All right. See, that has properly been moved and passed. Members, we're going to take a quick 3-minute recess and then go back to agenda item 5A. Thanks. Will the parties, now we're going to go back to section 5 on the agenda. Will the parties, and reading Nicole Freed, 21-079 or 97. Will the parties and their counsels please identify themselves for the record?
Good morning, Commissioners. Ben Cuney, counsel for Nicole Nikki Freed in this matter.
Okay, thank you. You could sit back down and, let's see, and then, all right, and,
Elizabeth Miller, advocate for the commission.
all right. So this matter is in consideration for the advocate's motion to dismiss the complaint number 21-97 and Nicole Heather Freed. If the commission grants the advocate's motion, the matter will be dismissed. Alternatively, if the commission were to deny the motion, the case will proceed to the division of administrative hearing and hearing, and both parties could reach a settlement agreement. All right, Ms. Miller, the floor is yours.
Thank you.
I just wanted to note that the complainant is also.
It's not here. Okay. Thank you. So I recognize Ms. Miller.
Thank you. As a candidate and subsequently as a commissioner of Agriculture and Consumer Services, respondent was required to file a CE Form 6 on an annual basis. Her 2017 and 2018 CE Form 6s were called into question because she filed numerous amendments changing the amount of income she received from Igniting Florida, LLC. That business was always listed on her forms, whether it was an original form or an amended form. In concert, the respondent's CPA and attorney filled out all of respondent's financial disclosure forms. According to them, at the time of each filing, an accurate snapshot of her income from Igniting Florida was disclosed. When new information was presented, they acted proactively to amend the forms on behalf of the respondent. The amendments were voluntarily filed and were not the result of a complaint. I believe that 3 scenarios were possible and 1 was plausible. First, there may have been faulty bookkeeping. I found no evidence of that. Second, the respondent may have intended to hide income or be deceptive. The evidence does not support that. But the more plausible situation may be that funds were not on the books to be counted. In other words, transactions may have been going on which weren't on the books, and that's a matter of timing. You have in front of you a motion to dismiss, and I respectfully request that you dismiss this complaint. Thank you.
Okay, do we have questions from members? Okay.
This is disclosure. I served in the legislature and worked with Commissioner Freed.
Any other disclosures? Sir?
Thank you, Mr. Chair. I also familiar with Ms. Freed. I consider her a friend, voted for her a number of times, but that will not impact my decision.
Okay. All right, any other questions for the advocate? Hearing none, the respondent can now make a brief statement.
Good morning, Commissioners. Nicole Nikki Freed was a first-time public candidate when filing her forms disclosure. She had not been a public official in any respect before. She engaged a lawyer well-known in campaign finance and financial disclosure, and a CPA accountant who not only did her tax returns, but became steeped in the financial disclosure requirements of the Florida Constitution. Both of those professionals worked with Nikki Freed based on tax returns prepared by the CPA and accurately transposed the information from the tax returns to the Form 6, the financial disclosures. Igniting Florida, a company, private company, on 2 occasions restated its income, which led to an increase in the funds Nikki Freed received for doing work as a lawyer and a consultant for that company. On the 2 occasions when Igniting Florida restated its income, the accountant took that information promptly, amended tax returns, and at the same time, with the lawyer, filed amendments to her financial disclosures. In doing so, the commissioner followed the letter and the spirit of the constitutional requirement for full and public disclosure. When this matter was set for probable cause and sent to DOA, the advocate and I spent significant time doing discovery, something that the commission said needed to be done upon making the probable cause finding. And it turned out that the information that I had disclosed in responding to the complaint was accurate, verified, not the slightest deviation from the fact that information possessed by Nikki Freed, given by the company, was accurately disclosed, and then when the company, through its own, having nothing to do with Nikki Freed, financial restatements, notified Nikki Freed of the adjustments that required an adjustment to her tax returns as well as to her financial disclosures. She did it promptly, and only after the amendments were done did a complaint get filed, simply based on the fact that financial disclosure form and amendment, suggesting, well, that means as a matter of law and fact, the first form was incorrect. But there are 2 parts to the FCOE jurisdiction on financial disclosures, all set out in the motion to dismiss, which was the result of this exacting discovery. One says there's a safe harbor if you utilize professionals who have the experience to assist with sometimes complicated financial disclosures and reasonably rely on them with full disclosure of the information. The applicant, the candidate, the signer is engaging in a good faith signature, true and accurate on the form. And second, there is a provision in a rule and a statute that says if there is a voluntary amendment. No compulsion, no investigation that initiates the amendment. The commission shall factor in as a mitigator in determining the appropriate resolution the fact that the filer made the voluntary disclosure. We believe, based on the motion to dismiss, the developed facts, that this is a test case for the incentive for elected officials to make their disclosures and feel fully confident that as new information comes to their attention, they should and have an obligation to make that disclosure, to let the public know the full and fair disclosure of information. We believe the motion to dismiss is appropriate, not only as a matter of fact, but as a matter of law under the guidance of the statutes and the rule that governs the commission. We join in the advocate's motion for dismissal of this matter.
Okay, great, thank you. Are there any questions from the members? You're recognized.
In the process of filing, is there a provision that requires you to do an amendment if you have no additional information? Is that part of the process?
You're supposed to file an amendment when you have up-to-date information, or if you realize that your original filing was not correct.
So filing amendments is allowed?
It's, not only is it allowed, we have a specific form for that, and it's Form 6X in the case of a Form 6 filer. That form formerly, at the time that Ms. Freed was filing her, making her filings, that was a paper form. Now it's electronic. It's available on our electronic system. But yes, absolutely.
Members?
Question.
Sir?
Who was the president and CEO of Igniting Florida?
The record does not reflect that, but the president of the company was then an associate business purpose and developed a personal relationship, which later, well after this fact, led to a relationship of not a marriage, but a domestic partnership, I guess would be the best explanation.
Who owned Igniting Florida?
Igniting Florida was an LLC owned by a number of shareholders,
Multiple
members.
shareholders.
Yes, not Nikki Freed.
She was not an owner at all?
No, she was a consultant for the company.
Any other questions? Seeing none?
I have another.
Okay, sir.
Something that puzzled me on this, and I'll throw it out for the record, that when I read through the complaint, and then when I read through the disclosures, the financial disclosure forms, that there were items on the second form that were not included on the first form the prior year, that there didn't seem to be any explanation or increase in income, or it just baffled me as to why that was not made part of the original complaint as to disclosures on income. I don't know if we can ask questions of the complainant here, but that absence left me unsettled, I would say. So,
Okay.
can we ask questions of the complainant in this process?
Steve?
No, through the chair, the complainant is not a party to this action. This is just a motion before you. The two parties are going to argue it. It's also not an evidentiary hearing, so we wouldn't be taking any testimony in this matter.
Okay. Any other questions, comments? Is there a motion to either adopt or reject the advocate's motion?
I move to accept the second.
Okay, it's been properly moved and second. Are there any discussions? Hearing none. All in favor of adoption of the motion, say aye.
Aye.
All opposed?
No.
Let the records show. that the adoption, the motion has been adopted. Thank you.
Thank you, Commissioners.
So item 7, which is, all right, let's see. Item 7, consideration of financial disclosure appeals. Appeal number FD 21-001. The first item is the financial disclosure appeal wherein the appellant requests a hearing. Is Mr. Adam Weisholtz present today? No. He is not. Okay. So now we bring up our staff member to present the draft order. Correct? Okay, cool.
Thank you, Mr. Chair. Good morning, Commissioners. I'm Joe Burns, attorney for the Commission, and this is Financial Disclosure Appeal Number FD 21-001 regarding Adam Weisholtz. Mr. Weisholtz was required to file CE Form 1 for the year 2020 pursuant to his position on the Judicial Nominating Commission for the 15th Judicial Circuit. That form was due on July 1st of 2021 with a grace period ending on September 1st of 2021. The Commission mailed him a blank Form 1 on May 26th of 21. We sent him a notice of delinquency by certified mail on July 30th of 21, which was returned to the Commission almost 2 months later, and it was marked not deliverable as addressed. We mailed him a courtesy postcard reminding him of his obligation to file on August 19th of 21. We sent a notice that an automatic fine had begun to accrue on September 8th of 21. And we did finally receive his form on August 5th of 2022 and his appeal of this fine on September 19th of 2022. And in his appeal, he did explain that he did not receive any of the mailings that we had sent him. He explained that they were sent to an old address, and he had a new updated address, which he did include on his appeal form. The evidence that he did not receive any of these mailings is uncontradicted in the record, and we do find that it is unusual that so many mailings would not reach the appellant, which satisfies the requirements in our rule to waive the automatic fine. And I'm available for any questions.
Awesome. Members, do you have any questions? You're recognized, sir.
Thank you, Mr. Chair, and I intend to support this, but I'm always interested in how is it that they find out after the fine that they then appeal? So I just can't understand how that happens. That's, I don't know, observation, maybe a question, I don't know.
Madam Executive.
No.
They always get that, but they don't get everything else before it.
Through the chair, your observation is correct. That is often the case. I will tell you that we do everything that we can during filing season to track these folks down, to get them notice. Sometimes the certified mail returned to us doesn't get back to us until after fines have started to accrue. But ultimately, through the diligent efforts of our disclosure staff, we can ultimately track them down and get word to them. And, you know, they are alarmed.
Thank you.
The notion of the, it gets their attention.
All right. So, members, do we have a motion to?
So moved.
Second.
All in favor?
Aye.
All opposed? Okay, see, the motion has been approved. All right, Joe, on to the next one.
Thank you, sir. This is appeal number FD 19-087 regarding Mr. Anthony Zogby. Mr. Zogby was required to file a Form 1 for the year 2018 pursuant to his position as a systems project analyst for the Office of the Governor. That form was due on July 1st of 2019 with a grace period ending on September 3rd of 2019. The Commission mailed him a blank Form 1 on May 15th of 19. We sent him a notice of delinquency by certified mail on July 24th of 2019 which was eventually returned to us as unclaimed on August 21st of 2019. The commission mailed him a postcard reminding him of his obligation to file on August 20th of 2019. We sent a notice that an automatic fine had begun to accrue on September 6th of 19. On February 10th, we sent by certified mail a notice of assessment of automatic fine, which was eventually returned to us on March 4th of 2020 as unclaimed. Sent a final notice of assessment of automatic fine on June 11th of 21. Sent a collection order notice and a default final order on September 15th of 21. On February 4th of 22, we sent a warning to withhold salary. And on February 21st of 22, the commission received the appeal of the automatic fine indicating lack of notice, also indicating that it was an old address that all of our mailings are being sent to, and he did provide an updated address on his new form, and he had a new position with the Department of Environmental Protection. We do find that the lack of notice due to him not receiving any of our mailings is unusual and satisfies our requirements pursuant to the rule to waive the automatic fine. I'm available for questions.
All right. Members, any questions? Hearing none. Do I have a motion?
So moved.
Okay, so the motion has been properly moved and seconded. All in favor, say aye.
Aye.
All opposed? Joe, good job. Today's my first day too, so good job. All right, now we move on to the reports. Our executive director, you're up.
Okay, I promised the chair yesterday and this morning that I will be as brief as possible so we can move to the next session. Briefly, to add to my executive director's report, you all know that we started a legal extern program last year, and at some of the commission meetings you've met a couple of the externs that we've hosted. We don't currently have an extern right now, and we sure wish we did, because this is a program we plan to continue. Steve's been in touch with FSU about having another legal extern this summer. We feel like it's been successful. It's brought value to the commission. Because the externs do a lot of work while they're with us. It's a significant amount of work. They assist our attorneys with a lot of staff tasks, and you know that our workload has been heavy. We have great news that is not only the extern program good for us, but it's good for our externs. Alexa Ravenscroft was our extern last fall. She just found out that she's been awarded a fellowship with the Florida Supreme Court for the next academic year, where she'll be assigned to an individual justice at the Florida Supreme Court as an intern. So we are very excited for Alexa, and we're proud of the experience that she gained with the commission and the things that our office might have done to help her get where she is. She was fantastic, and we are just over the moon excited for her and her career. That wraps it up for my executive director's report. You do have a litigation report in there, and because we don't have anything else to add, nothing else has transpired with that since the report was issued, there's no need to handle anything there, so I'll move on to our favorite thing to talk about, which is electronic filing. As you know, it's been up and running since January. There's only been around 60 disclosures filed so far. Any Form 6 filer can contact the commission, request a registration invitation for the new system so they can file their Form 6 or a Form 6X amendment as may be required. We did go live with the document upload feature. We've only had, I think, maybe one filer utilize it so far, and the system did perform as expected. We're in the process of finalizing some more training videos and preparing the system for the push of registration invitations to filers to come in the next few weeks. The other major development is that the official filer list that coordinators have been working through and that Kim and her staff have been working through has officially been cemented, and so we are preparing for all the wonderful things that are going to happen during disclosure season, as well as getting ready with the Form 1s that are currently scheduled to happen in January with that rollout. Is there a question?
I rarely get calls about anything related to the Ethics Commission, but I did get a call from a filer recently who asked why he was not able to save his previous report and come back to it, rather than try to input, why does he have to put everything in again? And I don't know whether he said it might have been operator error, or is that a software system issue?
Through the chair. If this was a filer who filed electronically last year and came into the system this year and couldn't access it, I believe that is a function of the pause and the restart. But at this point in the ballgame, we don't currently have it set to replenish, repopulate for the next year. That is something we are discussing that may be available in a future rollout. But at this time, it is not repopulating.
I want it, since it's public session, I want to have proof that I asked and that
You
you're
did,
working
you
on
did.
it. And
It is something that has been discussed from time to time over the years, and as we've been prepping it. One of the pitfalls of pre-populating a form for someone is something that you all have seen here with complaints, is when people have the information from last year and they just copy it to the next year, from one year to the next, might not be accurate. But we have heard that sort of feedback from others, so we've heard that.
I think it makes sense
It
to.
is something that we are looking at for future rollout. So, thank you.
Let me ask one other question, not related to this, but your litigation report. If it's appropriate to talk about, and if it's not, I'll accept that and go read the opinion myself. But I know it was a tough one, and it's been out there a long time, Patrick Loeb versus the commission, and that the DCA issued an opinion. I'll emphasize what was emphasized in the report, which is very sound arguments were advanced by the commission, and that was a very difficult case. I'm just interested in it in terms of the takeaways for us, if any, that we might either learn where the court is coming from on the legal issues on which they ruled.
Through the chair, I guess I'll address that because I'm the lawyer that argued it. We argued it in this courtroom this summer.
Well, I heard.
Oh, well, we tried our best. We were not successful. They did reverse the commission's decision. Essentially, if you remember, that case concerned the 2-year post-employment representation ban that was applicable to the taxpayer rights advocate for the state of Florida. That ban is just applicable to the agency where you were employed. So the issue in the advisory opinion before the commission was, what agency is the taxpayer rights advocate employed by? He was administratively housed at the Department of Revenue. He was subject to the administrative control and was paid by the Department of Revenue. But in terms of his responsibilities, the law has recently changed, and he was to report to the Chief Inspector General's office in the office of the governor. Our argument, which you adopted through the advisory opinion, was because he was paid by Revenue, because he was administratively housed there, he had a great deal of influence there, that Revenue would be his agency. On appeal, what the first DCA did was they found that while that might be true, equally true is the fact that he was subject to the control of the Chief Inspector General. They had the ability to control his work. They had the ability to appoint and remove him. And so ultimately, the first DCA found, I think essentially because they had the ability to control his work, that his agency for the purpose of 9A4 was the Chief Inspector General's office. That's what the court did.
Okay.
I won't be a sore loser, but that is tough to understand.
All right, Madam Executive Director.
Now, I guess moving on briefly to legislative report, we are, of course, in session. We are monitoring a number of bills and hopeful as ever to move some ethics legislation this year. I guess I'm an optimist at heart. To that end, we have the Enhanced Financial Disclosure Bill filed by Representative Roach in the House. It's passed through one committee so far. It's now a committee substitute. Turning to the Senate, Senate Bill 774, I believe by Senator Broder, is the Senate companion to House Bill 37. They only differ slightly. The Senate bill is scheduled for its first committee this coming Tuesday. Similarly, Senate Bill 620 by Senator Burgess. That was the bill that was striking the exemption in the 112.313 sub 7 that applied to certain independent districts, and it also applied a 4-hour mandatory training requirement to these certain special districts. There was a delete all filed that reinstates the exemption, but with some clarifying language that would indicate that if the conduct violates the misuse statute or the inside information statute, then it would in fact create a sub 7 conflict for special district board members. That bill is also scheduled for Tuesday. So by the time we meet again, we will be nearing the end of the session. So between now and then, we'll be working hard on the things that you have put before us. I'll be working with the chair and the vice chair and other members who might have contacts that can help us move the commission's recommendation, and we will cross our fingers and that completes my report.
Awesome. All right, well, thank you. I see that Commissioner Newton makes a motion that we adjourn today's meeting. And thank you, everyone. So we'll take a break to 10-15 minutes, and then we'll be back at 11 o'clock. Thank you, everyone.